Hi, this is Steve Carlson, 2016 independent candidate for President of the United States from Minnesota. And I've been the nominee for the Minnesota Independence Party for the U.S. Senate against Al Franken and Mike McFadden. This is the fourth video on the action at the Minnesota Supreme Court on free and fair elections. And I've briefly shared some of my positions in this series. I don't just sue. In fact, I did no such thing in my 2010 race, and Al Franken is the one who sued his way into the U.S. Senate. And actually now in Minnesota we follow, the Minnesota courts erroneously follow, Al Franken's harebrained ideas. Please note my statement is that Al is harebrained and his attorneys are harebrained, and the Minnesota Supreme Court is just erroneous. They are erroneously following his wrong-headed ideas. I've talked about immigration, I've talked about religious liberties, climate change, I've talked about consumer lending and the 35% of households in collections in a recent survey. I've talked about the national debt and deficit and about our healthcare system and healthcare reform that is not Obama, and which restores the health of our healthcare system. And now in this final introductory video, I want to put forward critical constitutional election litigation for independent voters throughout the United States, using Minnesota as just one example. I want to talk about the 6%. The 6% are the caretakers of America. Sometimes all of us are takers, okay? And we should be grateful. Because of who we are, we're Americans, partaking of the bounty and blessing of America. Now, it's not just land or power or its wealth. And there are times when each one of us is a giver. Not just when we pay taxes and serve our country. We can give when we vote to take care of America, and not just our perceived self-interest. And the independent voters, especially that hardcore that will go all the way to vote for a third-party candidate, rejecting the Democrats and rejecting the Republicans, are caretakers. This is not based on race or gender or religion. 6%, which is the typical achievement of nascent independent parties. John B. Anderson got 6%. I got 6%. A lot of our people get up to 6% when we're in the opposition. We're not one of the big two that control the government and control all the resources. And it's a very special number. Well, it's close to the typical margin of error, isn't it? The number that makes close elections exciting. But it is also the original percent of Americans of voting age before the rise of the national parties who were eligible to vote. And so they were taking care, they were largely property owners at that time, but not always. It varied by the states. They were usually the amount that voted in national elections. Now, I'm not in favor of limiting the voting to those 6% by any means, but that's a very special number. And since the rise of the two national parties, they've torn America apart with our type of voting problems, because they were incapable of forming a government that would preserve the Union, leading to the American Civil War. And today they are tearing America apart. And while they're doing that, they're also tearing the Republican Party apart. Now, Republicans are the party of Lincoln. But when he was killed after the terrible Civil War, they were taken over by a mob from New York, radical Republicans, people like Al Franken and Hillary Clinton. And they went on to rape the South, taking advantage of the Civil War to enrich themselves. They've left centuries of resentment, which we need to heal. We need to be healers, not dividers. It's not enough to be a uniter. We need to heal, and healing requires participation of true national leadership. And when the carpetbaggers play on race, they are creating and prodding painful divisions. And so we desperately need free and fair elections, which by their very definition are not divisive, because they are designed to lead to the best laws, the best government, and not just to obliterate the received truths of the political opposition. They allow debates. They don't squeeze them out. They allow free expression and free association and don't trample it. Oh, how tempting it is to achieve your special truth, your great vision for the nation by eliminating dissent, eliminating diversity of thinking, and eliminating those caretakers who need to give the nation its balance. Free and fair elections, if we had them, which we don't, and Bush v. Gore v. Nader in Florida showed that, and Franken v. Coleman v. Barkley has also been used in Minnesota to begin a backlash by the Democrats and Republicans against the independent voters in Minnesota. And the Minnesota Supreme Court has allowed both parties to quash any independent oppositions. And they have erased the most advanced vehicle of independent voters in the nation, the Minnesota Independence Party. But the U.S. Constitution allows us to fight back, to require fairness and freedom in elections and voting, which is what I'm doing. And to put it very simply, this is fundamental to the nation, because every 2 years, through free and fair elections, we reconstitute America. Out with the old, in with the new. It's a gradual change. And we hope this allows us to hold on against the tyranny of the Democrats and the race and gender and anti-religion attacks of Barack Obama, Hillary Clinton, and the rest. And Republicans would have you believe, as Mike McFadden said to Michelle Bachmann in the 2014 debacle, "Trust me, we'll protect your freedom of conscience and your religious traditions and faith." But I'm telling you that's wrong. You cannot trust the Republicans. You must trust the caretakers. Be a caretaker. Not a taker, not a giver, but a caretaker. The caretakers will lead. They care so much. They inform themselves no matter what the difficult circumstances the nation faces. And we rely on you to get this nation on an even keel. And it has to be a national movement, because no single state can get the 50 states on an even keel. I am concerned about every issue that affects America, including the urgent need to transition power and resources from the federal government back to the states. And I want to talk a little bit about freedom of conscience and the related issue of religious liberties in a broader context. The 6% in the nascent new party cares about the states they live in. I believe the biggest driving force among independent voters today is a concern about the growth, the overwhelming growth of Washington, D.C., because it is eating up America and everybody knows it. But caretakers also take care of their families, not just money for a group, but a true family. We want to create a lasting environment that will last through generations. So we're not pleased if we get new possessions which don't last, or if we just make a little progress, or avoid problems for a while, or live paycheck to paycheck. And we know that if we take care of America, we will take care of the Commonwealth. And this cannot exist without freedom of conscience. And I believe that America benefits from a healthy Catholic Church, just as we benefit from the protection of faith, of freedom of conscience in general. And yet the Democrats, with their gender, race, and homosexual quotas today, want to make Minnesota the capital of the national capital of the destruction of the Catholic Church. We as Christians, we as people of faith, including Islam, Buddhists, and Hindus, Jews, and Christians, and native religions, must stand for our Constitution, stand against this state who destroys religion and who takes over your conscience and tries to teach you that what is evil, what is destructive, is good for you, and uses unfair elections to impose tyranny of conscience on you. I would not persecute the homosexuals and lesbians. I want human rights for them, because that is their salvation, on which this nation is founded, freedom. But now, having seized the federal government through Barack Obama, how many of you thought the 2008 election was about race? No. Now they want to become the persecutors. And we must assert the freedom of conscience of this nation's Constitution. I want Minnesota to become the source of constitutional healing, not continual and constitutional perversion. I want to strengthen and protect civil rights and human rights because this is where our caretakers come from. And I have positions on many issues I've developed since I first became the nominee for Congress in 2010. I'm a radical centrist and a problem solver, and I think voters want someone like that in any presidential race. But as I said in the first 3 videos, in Minnesota today and throughout the nation, the 2 national parties, the Democrats of the Obamas and Clintons and the Republicans of the Bushes, have conspired to trample on the rights of independent voters. And you don't hear a lot about that from the Republican candidates. And we need to hear their voices too, or from the Democratic candidates. They're instead promoting their own national parties to get an edge in 2016. Now in video 4, in video 2 actually, I introduced George Newman, kind of a generic name. George, new man. His identity is litigator, who has responded to these videos extensively on Twitter. He responded to my claim, which I have clearly shown, that Hillary Clinton's Democrats are abridging and denying voting rights in multiple states. It's reached the point where Newman, who is licensed to litigate election law in Virginia, Maryland, and the District of Columbia, has suggested I might be jailed if I don't drop my public allegations, that the Minnesota Supreme Court has deliberately covered up and excluded from the record the clear fact that Minnesota Governor Mark Dayton, former Governor Mark Ritchie, and Al Franken conspired and colluded to illegally issue Al Franken's election certificate to the Secretary of the Senate, while Franken was still facing this contest. So let me first address the voting rights decisions by the Democrat Party, which initially drew Newman's attention. This anonymous attorney is publicly urging that instead of a response from Franken, Dayton, Simon, and Swanson to my motion for a rehearing, he wants contempt and continued stonewalling against the complete congressional election code required by Article 1, Section 4 of the U.S. Constitution. He says the Constitution offers no protections against violations of constitutional rights in elections in the states for the U.S. Senate and the U.S. House. He says you can't bother a state court about First Amendment violations or denial or abridgment of voting rights, he says. It's insane to require this, he says. It's all about counting, vote counting. Fidel Castro has always got a lot of votes. Saddam Hussein, I could go on. America is not just about counting votes, it's about more. And the state courts need to do more, or they fall short of the Constitution and fall short of the requirements of Article 1, Section 4 of the Constitution as spelled out to Minnesota in a 1932 case called Smiley versus Home. I've gone into that at length in the first 3 videos of this presidential campaign series on free and fair elections for independents. And in this final video, I'm going to survey other landmark First Amendment cases for free and fair elections. And I'm going to finish knocking down the basis the Minnesota Supreme Court is relying on to bar even considering constitutional rights under the state's contest provision, in which the Minnesota courts are to play a limited role, or under our petition provision, in which they have greater power. And now, as I've pointed out, Al Franken has absconded with a false election certificate because he does not want to face the music of his unconstitutional, invalid election, which cheated the voters and destroyed the party of the caretakers. So again, there are a huge number of independent voters in Minnesota and the nation, and this election litigation, which I am bringing myself pro se, I am not a lawyer, is to restore those rights. I'm fighting for voting rights, which are being denied in Minnesota based on gender, based on race, and the state of Minnesota. During a time the Democrats controlled Minnesota state politics, they have passed a law to abridge and deny participation in voting based on sex, based on race, and based on suspect classifications in clear violation of the United States Constitution. In litigating to achieve free and fair elections, I'm building on a successful U.S. Supreme Court case from the 1980s called Anderson versus Calabrese, and the case is about independent voters and their parties. But since Anderson's been decided, it's been Democrats and Republicans who have seized on the decision and declared that it is protect their rights of association when the case talks about the need to protect independent voters. So the U.S. Supreme Court has addressed the role of free and fair elections without fettering the use of a small party's association and expression as follows in Buckley versus Vallejo, 424 U.S. 1, 1976. Now, I believe Buckley probably was running as a Republican, but he was using a lot of his own independent wealth. And they wrote, the First Amendment affords them, I'm talking about candidates and voters, the broadest protection to such political expression. And I could actually just say it affords the broadest protection to such political expression as the use of his own money. And here it would be the use of the voter emails that are public information, be the use of free and fair candidate debates, would be the absence of abridgment and denial of voting in the precinct caucuses, be equal justice. But it's in order to assure the unfettered interchange of ideas for the bringing about of political and social changes desired by the people. And that's citing Roth versus the United States. That's a 1957 U.S. Supreme Court case. They go on in the Buckley case. Although First Amendment protections are not confined to the exposition of ideas, so for instance, it would protect the use of the public information. That's from Winters versus New York, from farther back, 1948. There is practically universal agreement that a major purpose of that First Amendment was to protect the free discussion of governmental affairs, of course, including discussions of candidates. So we're talking about debates there. This is from 1966 in Mills versus Alabama. This no more than reflects our profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, citing New York Times Company versus Sullivan from 1964. In a republic where the people are sovereign, the ability of the citizenry to make informed choices among candidates for office is essential, for the identities of those who are elected will inevitably shape the course that we follow as a nation. As the court observed in Monitor Patriot versus Roy, 1971 U.S. Supreme Court case, it can hardly be doubted that the constitutional guarantee has its fullest and most urgent application precisely to the conduct of campaigns for political office, unquote. And this is to the Minnesota Supreme Court. This is your urgent duty. Anderson versus Calabrese, 460 U.S. 780 from 1983, cited in my petition at page 5, explains the burden on the associational rights of the independent voters whose association focused on the Minnesota Independence Party and petitioner's campaign. And I said that each ground shows a burden that falls unequally on, and these are the grounds that I put forth, the denial of voting rights and participation, the use of public information from the voter emails that Mark Ritchie cut off from me in 2012, equal justice in the courts so that constitutional rights are enforced, and then, of course, Al Franken's absent Al, famous shutting down of all debates for the Independence Party, and this was also done in the governor's race. They used Hannah Nicollet when it was nice. Now, in the congressional races, I believe that they were generally included, but when they got to the statewide, the ones that count, they killed them. They put a few in for Attorney General, for Secretary of State, but I don't think people generally paid attention to that. The ones that were critical to save and protect the rights of independent voters here, and it put a real burden on those voters in this party by pretending that they were following the law in cutting us out of the debates and statewide contests. And so these are the grounds, and I said in the petition that each ground shows a burden that falls unequally on independent candidates or on new or small political parties, and so impinges by its very nature on associational choices protected by the First Amendment, and discriminates against those candidates and voters whose political preferences lie outside the existing political parties. Now I'm quoting Anderson there. So now I want to turn to these pretexts which the court uses to say they will not get into any constitutional issues during an election. You're on your own against their big parties, whom they all represent, either Democrats or Republicans. Right now it's true. Republicans dominate that Supreme Court because they were mostly Pawlenty appointees. But their election expertise is David Lillyhawk, who is the election lawyer of Al Franken in this case. And so Coleman versus Ritchie cannot stand as a defense of refusing to enforce these requirements through 204B.44. Because on the contrary, it shows how 204B.44 and 209.12 can provide a balanced approach to protecting those associational rights protected by the First Amendment through petitions or contests, just as a mandatory recount is critical to ensuring the true vote in a close race where the survival threshold is at stake in the same number for smaller parties and independent votes and voters. The true vote is just as important. And that's what they relied on in Coleman versus Ritchie. Now, there is no serious risk that either the Democrats or Republicans are going to be blocked from debates by a media and the editorial discretion of the media, because voters and not only the parties would cry foul. But addition, there's enough of them that they can make it count. Now, in addition, each of these parties is a paying customer of the media, who survive on bloated election campaign spending, which the Democrats shout about, but they take the money. They're not unbiased in selection of participants. The media are not. They're motivated by money in ever greater amounts. The parties can trample the independent voters if our rights are not protected by eliminating the kinds of practices protested by myself since 2012, and whose continuation surely contributed to those practices. Continuations surely contributed to the present elimination of the Minnesota Independence Party as a major political party. Now, I discussed those U.S. cases in the context of looking at, I believe that was Coleman versus Ritchie, which is the counterpart to Franken versus Pawlenty. They both filed election petitions. And Al was told he cannot get that election certificate when there's a contest, but he still took it in 2012. He should know better. Now, Clark versus Ritchie. This was a case involving Chief Justice Gildea and her opponent. Gildea was appointed by Pawlenty, and this practice is controversial among lawyers. And 204B.44 was used to challenge a ballot issue, in this case Clark versus Ritchie. The issue being whether Gildea could be on the ballot because Pawlenty had allegedly violated the law or Constitution by appointing her rather than her being elected. And so the argument was she should be removed from the ballot. Well, that's what I think lawyers might call a creative legal theory. Now, this case was a case regarding the duty of the governor, and he is an individual who is required to follow the constitutional requirement that all judges be elected, and that was theoretically on trial in this case, and they did address it. They did defend it. The Supreme Court justices did defend the way they all got elected. And it was said that that the Constitution barred him from arranging that Gildea be appointed based on a questionable vacancy, which necessitated the appointment. In other words, probably they could have held out. I mean, every one of them has got appointed, so it's pretty hard to believe that in every case they couldn't simply fill out the term which they accepted. Now, this had a relation regarding the election Clark was to run in, And so I think it was related to an election, and it had a specific relief. And I think in dismissing it, that there should have been a hearing that should have been allowed. I don't think it was. Now, you argued, I'm talking to the Supreme Court here, that the governor is not required to allow the position to remain open or talk to the lawyer to ask them to stay on the bench. That is the kind of legal disposition of this, and essentially, instead of dismissing it, they discharged the petition without a hearing. Now, you refused to force Gildea off the ballot because Pawlenty had appointed her. There's absolutely no reason why there could not have been a hearing about this, and you could have issued the same decision. You could have discharged it on the grounds that you could not force Pawlenty to unappoint Gildea and that she should still be able to run even though the governor appointed her and she wasn't elected. She had an advantage that was unfair. The same argument could have been made about Dean Barkley when the IP governor, Jesse Ventura, appointed him to the U.S. Senate, that since he was the incumbent, I don't know the merits of the Clark case. The point is, it could have been dealt with on a petition, and instead it's being used as a precedent why you can't address the constitutional rights of independent voters. Now, however, this case may be distinguished from the instant dismissed petition because it involves the right of Clark's opponent to be on the ballot. It was a purported duty of the governor that had not been faithfully performed. That is to say, the idea that he should leave the judgeship vacant until the election could fill it, and that he didn't do that. But the penalty was to be on Gildea for accepting the appointment and taking the seat. In my petitions, I simply asked that the election rules be followed. I do not argue who may run for office, and I think that's a definite distinction here, and that should not stand as a precedent to exclude this case from a petition. And especially when Al Franken has run off with the election certificate while the contest was pending, a clear violation of Minnesota law. This definitely has to be cured by the petition. Now let's go on to the Minnesota majority case itself. This was a case about the Help America Vote Act in 2002, or HAVA. And I think that's like the voter email issue. George Newman says there's nothing to do with HAVA, but my understanding is that was the event that pushed the legislature to put this in, that there was the HAVA and they had to pass a lot of laws, and during that this was passed. I am going to take a closer look at HAVA to see if there actually is anything in there about email addresses. The important thing is it was passed. It did create government data that is collected. And certain people use that, like Mark Ritchie, and certain people don't use that. But that was the case. But it did not involve voter rights directly, or any of the First Amendment rights, like the voter email issue did. Instead, the case the court applied in 2012, because they applied this to block a contest that I filed from getting to the U.S. House of Representatives, so they applied this case. And again now, to refuse to hear any of the claims dealt with that dealt with the duty of the secretary, instead, it did deal with a duty of the secretary and county auditors to do list maintenance on the SVRS, the statewide voter registration system, in compliance with Minnesota statutes. There is not any reference to any federal rights, where mine are all based on federal rights, and all include equal justice, First Amendment rights of free expression and association, voter rights directly against suspect classifications, and abridgment and denial of the right to vote and ballot access for independent and small parties. I suppose you could say that they had some kind of right to look at a list, and they're saying that's a federal right. I don't think so, because the 6 weeks is a state right, but it's not the kind of thing that you could file a contest about, certainly. And I think it's a wash whether it could come in, but this is the kind of thing that you could say in a hearing under the petition statute, but they didn't want to do it. Furthermore, the case, which was brought by 6 Republican members of the legislature, including lawyers like Tom Emmer, was about an issue which the legislature itself set up an administrative channel to hear complaints about. So the issue was the list maintenance had to be done within 6 weeks of the end of the election of 2008. As such, I don't agree it was regarding an election, or even that it didn't seek a specific remedy with respect to that election. But it is not relevant here. Minnesota majority could not have been brought as a contest within 7 days of the canvassing meeting, well, because the state still had another week or so at that time to fix the list. So it is not comparable to this case, where there was a direct impact on the 2014 election, and a remedy of declaring the election invalid is available with respect to that invalid 2014 election. A remedy is also available for me as the nominee of the Independence Party seeking to compete in the IP primary in 2016. That is, reversing the loss of the major political status of the Independence Party. Reversing the elimination of the Independence Party so fervently sought by Sarah Janicek publicly on at issue. So far as the original jurisdiction of the Supreme Court, that also has nothing to do with this case. Minnesota majority was about voters in both state and federal elections. So there was an argument for original Supreme Court jurisdiction because the votes were in federal elections. I mean, it's very iffy. This is the kind of thing that lawyers who are politically powerful can do. However, now, people who are not lawyers, who are just independent voters, can't do it, according to the mixed up thinking of the current Minnesota Supreme Court. So they're erroneous and mixed up, and follow the harebrained ideas of Al Franken and his election attorneys. Now, as such, these decisions of the court in Minnesota majority were not material to this case and are mere dicta. And the form of the finding of the court in this case in 2013, which is now, in other words, they took this in my case in 2013, and now they've applied to other cases to bar anything but, quote, ballot issues, unquote. It indicates that it's just words. It had nothing to do with my case either, because there was nothing about ballot issues in that case that they had to decide. So it's just words. Now they're talking about any issue with any relation. What does that mean? It's mere puffery. I'd say that's an analogy to a statement or claim that expresses subjective rather than objective views, which no reasonable person would take literally. Nobody could believe that there's a whole bunch of infinite issues out here that have to do with any issue. That's an infinite set of any relation, and that's what the law is about. And so nobody would actually believe that literally. The court is advertising. Rather than following and enforcing the laws, you are bound to enforce that it will simply not hear anything except ballot issues. But where in the state law is there anything resembling a justification of this claim or intent of this court's policy? Where does it say that one candidate can bring a constitutional claim regarding irregularities in the election, but only if he hasn't raised the same claim in another election? And if he has, only another candidate or voter could do so to make sure the election is constitutional. This allows these constitutional violations to go on protected by this court from judicial scrutiny. It creates an uneven playing field to bar access to the courts in an election, because the election laws allow any individual to file under the petition provision. So therefore, this court's logic is that as soon as any unconstitutional condition comes into existence, like, say, gender, race, and sexuality quotas in selecting voting delegates, the entire population of the state over the age of majority had a legal duty to file the petition or forever waive their constitutional right. Even if this was the intent of the legislature, it violates the Constitution, because all voters have a right to see that every election is free and fair. And under the U.S. Constitution affecting federal elections, that covers not just ballot questions, but voting rights, freedom of expression and association, ballot access rights, equal justice for independent voters and small and new parties. Indeed, in Franken versus Pawlenty, 2009, this very court cited Smiley and Rodebush as allowing the election contest to go on. though Al said the Constitution requires 2 senators and requires that the Senate reorganize January 3rd following the election year, and so he says it was constitutionally required to stop the contest. That is obviously patently absurd. And yet, given the, and you can check my footnotes on that, Al, it's patently absurd. And yet, given the national attention to the race, this court heard that petition and had the required hearing. This is unequal justice. Frank can bring a petition and get an answer why he can't get the governor to release the election certificate through a contest, although a contest is pending. But I cannot bring a petition and get his illegally issued election certificate revoked and the contest revived. And this is because I'm with a small party. But you overlook the material fact that I only need to get 5% to keep the party on the ballot. And if you don't like that, go to the legislature or the FEC and change the laws. But don't prejudice independent parties and candidates and voters with refusal to give equal justice. This is a misapplication of this decision of the Minnesota majority to deny voting rights, First Amendment rights in an election, equal justice with the Republican and Democrat parties, where the burden on refusing to enforce the laws falls more heavily on the independent voters, candidates, and parties. And again, I think they should enforce the laws, these kind of laws, with all the parties, big or little. But even if you're not going to enforce them with the big parties, if you don't enforce them in our elections, that is a burden which falls unequally, and you cannot justify that practice under Anderson. Now here's another one, Begin versus Ritchie. This is from 2013. This is about the Green Party, Ralph Nader's party. Yeah, they got it coming from that Bush v. Gore. Okay? Like the Independence Party, it's a small party that needs to get equal justice in the application of this law, and its margins are smaller. Its goal is to stay in business to promote the goals of the associated voters who make it up. Yet my 2013 case was used as the predicate to find, because we conclude the Green Party's claims fall outside the scope of Minnesota Statutes 204B.44, we dismissed the petition. The issue here was not vote count. It was an attempt to make up for the failure to file paperwork before the Secretary of State decertified the group as a Minnesota minor party. That's not a major party like the Independents. It's a minor party. I think they needed a smaller percentage to stay on the ballot. I think it's like 1 or 2%. But in the eyes of this court, there's no difference between failure to file, thus losing status, and losing status as a result of an allegedly invalid election. What you should have done under the plain language of the law is hold a hearing and determine that the Green Party did not file its paperwork on time, and it was not within your power to extend it, or if you chose, go ahead and extend it. Secretary Ritchie could have said there is legislative intent that the time for filing not be extended, or that it was within his discretion as secretary to extend it or not, and he chose not to extend it. You could accept it or overrule it, and that would be that. There's no reason to create a whole universe of cases to draw on any time you choose not to simply follow the procedures prescribed in the election law. Now here's an analysis applying the Complete Congressional Election Code. I call that the CCEC. The fictional George Newman says that's fictional, to the grounds presented in the petition. So I'm going to apply the very real CCEC to the grounds presented in the petition. A multi-perspective analysis of the grounds presented for the petition shows how critical it is for the court not to limit its enforcement to ballot issues or exclude indefinite infinities of types of issues it will not consider in maintaining free and fair elections that respect the independent voters, independent party candidate or nominee, or small parties as associations of voters in elections. A good place to start is the debate. In Arkansas, Educational Television Commission versus Forbes. I call this Forbes. Randy Forbes is currently in the Congress. This is in 1998. And U.S. Supreme Court. The U.S. Supreme Court talked about the election debate traditions. They talked about the tradition of debates, not the rights. For some reason, democracy is now a tradition. Now, and they said, although public broadcasting as a general matter does not lend itself to scrutiny under the forum doctrine, candidate debates present the narrow exception to the rule. So that's saying it's subject to the First Amendment. For this reason, for two reasons. A candidate debate, like the one at issue here, is different from other programming. First, like AETC's other broadcasts, the debate was by design a forum for political speech by the candidates. Consistent with the long tradition of candidate debates, the implicit representation of the broadcaster was that the views expressed were those of the candidates, not its own. The very purpose of the debate was to allow the candidates to express their views with the minimal intrusion by the broadcaster, for instance, kicking him completely out of the debate. In this respect, the debate differed even from a political talk show, whose host can express partisan views and then limit the discussion to those ideas. And of course, the debates do this too, but in intent that it's not supposed to. Now, second, in our tradition, this is the U.S. Supreme Court, I believe it's Stephen Breyer, candidate debates are of exceptional significance in the electoral process. It is of particular importance that candidates have the opportunity to make their views known so that the electorate may intelligently evaluate the candidates' personal qualities and their positions on vital public issues before choosing among them on Election Day. And this is from CBS versus the FCC. Now, both those two parties were involved in helping to exclude debaters against Al Franken, who's a big FCC kind of TV, NBC heavyweight. So he knows all the ins and outs and buttons to push to stop democracy. And this case was from 1981, where they talked about this particular importance. And now with this AETC, the Forbes case, Justice Breyer goes on, deliberations on the positions and qualifications of candidates is integral to our system of government. An electoral speech may have its most profound and widespread impact when it is disseminated through televised debates. A majority of the population cites television as its primary source of election information, and debates are regarded as the only occasion during a campaign when the attention of a large portion of the American public is focused on the election, as well as the only campaign information format which potentially offers sufficient time to explore issues and policies in depth in a neutral forum. And this is from Congressional Research Service, Campaign Debates in Presidential General Elections. This was a general election, and it was the summary. This is from June 15th, 1993, the same year that the World Trade Center was first rocked. Now, as we later discuss, in many cases, it is not feasible for the broadcaster to allow unlimited access to a candidate debate. Yet the requirement of neutrality remains. Now, I'm saying this is a major Minnesota party, the IP. It has equal rights as a party, legal rights, as the other two. So this is not unlimited access. And so the Minnesota Independence Party is going to be treated differently than the Communist Party or the Libertarian Party if they have not met the threshold of becoming a major party. And so in this one, though, they do go on to distinguish with the requirement of neutrality. A broadcaster cannot grant or deny access to a candidate debate on the basis of whether it agrees with a candidate's views. Viewpoint discrimination in this context would present not just a calculated risk, citing the CBS case, but an inevitability of skewing the electoral dialogue, unquote. Well, it is the skewing of the electoral dialogue which is what is objectionable when the Duluth debate organizers, including Al Franken and including Mike McFadden, say that, well, the Democrats and Republicans control most of the Senate, all the Senate, or virtually all the Senate, therefore they decided just not to include the Independence Party, which is what the evidence of the record in this case is. That is viewpoint discrimination, because we know that viewpoint is involved in all the parties. They not only present different candidates, but they supposedly have different principles and viewpoints. So this was violated. And I think for the other two debates as well, that you're excluding a major Minnesota party with that viewpoint. So whether you come right out in the open and say that, as Chuck Fredericks did, the debate organizer in the Duluth debate, which Al first agreed to, just with Mike McFadden, though. So it also controls, and you have to include the Independence Party in these public broadcast debates once our status is restored because of the invalidity of Al Franken's actions and the actions of the other respondents. And under a contest, this is something that needs to be considered by the United States Senate, and in light, for instance, of their equal time requirements, which they passed, and also the U.S. House of Representatives, who also passed those. And the overall treatment of this case is subject to review by the U.S. Supreme Court for constitutionality. Now, the goal of the Republicans and Democrats, expressed so eloquently by Sarah Vanasek, I believe it's Janasek, and the GOP spokeswoman on At Issue, and that is who she is, was intended to. And if this invalid election is allowed to stand without scrutiny, it will inevitably skew the electoral dialogue to the detriment of the voters and independent-minded Minnesotans. As an example, here's from the Star Tribune. 6 weeks before the 1998 gubernatorial election in Minnesota, the Star Tribune pegged Reform Party candidate Jesse Ventura at 10% in the polls. 3 debates later, on October 20th, he was at 21%. Remarkably, Ventura's cash-strapped campaign had not yet aired a single television advertisement. He got to 21%. Now, on Election Day, Ventura captured 37% of the vote and became the governor of Minnesota. And Governor Ventura explained his astounding victory. I was allowed to debate. I proved that you could go from 10% to 37% and win if you are allowed to debate. Rest assured, these two parties don't want to ever see that happen again, unquote. Combined with my social media presence, participation in debates as I participated in 2012 and 2010 would have driven my results higher in the same way. The 50,000 or so who weathered the difficult election environment and suppression of information to vote for me are deserved when equal rights cannot be secured in a democracy. The 10% threshold for debates, and I did poll 13% in July 2014 per Huffington Post, makes no sense when the party needs 5% to survive. So why, if you have a legal framework in which the party only needs 5% to survive, but you're going to keep them out of debates so they don't reach that 5%, and that's because they're not polling at 10%. So it's totally illegal under our structure to require 10%, besides the fact that it doesn't make any sense. Now, this gives the media, as, quote, editorial discretion, unquote, the power to edit out free association and free expression from the U.S. Constitution and actually edit out the Independence Party as a whole, which they did, eyes open. And they should be ashamed of themselves under the First Amendment. The special hard-earned status of Minnesota political party or major political party cannot be rubbed out through the unconstitutional practice or any of them challenged in my petition in my election contest. Again, and finally, I did not abandon the contest, as Justice Gildea erroneously said in her challenged order. Instead, I met what I could fairly term an underhanded, Republican-driven manipulation of the rules by withholding from me my copy of the order of the Chief Justice, so I was unable to respond to it. It is not the case that I replaced the contest appeal with a petition. I just felt that regardless of this court's ideas about whether I could void the contest so grotesquely deformed by your panel, there was definitely a need to file a petition because of the obvious present duty of the governor and secretary of state and Al Franken to abide by the Minnesota election law, regardless of what action the Senate took based on the illegally issued certificate. The other grounds are included to make the petition complete and to recognize the fact that Minnesota courts and the U.S. Supreme Court share jurisdiction over these matters of voting rights, free speech, and free association, ballot access, and equal justice for independent voters and independent and newer or smaller parties. And also the Senate shares that. And that this court is mandated to protect all the rights supposedly secured by the Constitution, so they will not be nugatory, and government of the people, by the people, and for the people, and not the parties, shall not perish in this great republic. So you knew the end of that brief was coming. So I'm Steve Carlson. I approve this litigation. I approve this message. I approve this campaign to support independent voters throughout this country, the caretakers. And I ask you to continue to look at my issues and the issues of independent candidates and voters all around this country and not be mind-numbed and brainwashed by the big media who are accepting now billions of dollars from people like Hillary Clinton and even the Republicans. People complain about the Libertarian vice president candidate from 1992. I believe his name is David Koch. And they want to reform the First Amendment, Al Franken and Amy Klobuchar do, so that they can put all the power in their own hands and tighten the hold that the major parties have over congressional and even legislative elections. We don't want to be brainwashed, so that's supposed to be our freedom. Our Constitution requires us, all of us, to take on the duty and the obligation and the burden and sacrifice of finding out what's going on so that we can ensure that the kind of decisions that are taken by our government is one that's going to perpetuate us into the future and protect the freedoms. Yes, we do have freedoms. And others who come into this country, and others even who felt that they've been oppressed or excluded, and I think many of us can feel this way quite justly, that or feel that when others have religious freedom that it somehow lessens us as a human being. Well, it does not. And we need to stand up and we need to take that duty year after year, and our parties could aid us to do this. Unfortunately, what they do now is to block us from doing it. As was said by one of Thomas Jefferson's friends early on in the history of the Republic, that what these big parties tend to do is they tend, especially when at the closer the race, the less they're going to listen to the other person and the less they're going to attribute any quality of truth to what that other party is saying. And so it just drives this explosion of polarization, which is rending this country apart. And that's why I jumped in the race in 2010. I saw this happening. I didn't do it right after 2008, although I did pay attention. But I still see it happening. And in the future, how many of us actually see a future for America as we know it today? There are people who hope there's going to be some kind of totalitarian government, a socialist system, totalitarian system. And maybe those people see a future for America. But that's not America. That's the future, but it's not America. And so if you want there to be an America, you need to find out what is going on in the elections, what the courts are doing, what they're not doing, what this big money is doing to buy judicial power, what it's doing to buy the power of the broadcasters. And Congress itself passed a law saying, the Communications Act of 1934, they recognized the power of broadcasting, and they said, no, you cannot use that to interfere in the election and interfere with the rights of legally qualified candidates, which I am, which all of the Minnesota Independence Party candidates were. And if other people get on the ballot through petition, they are. And it gets tough when you got 30 people for president, even right now with the Republicans. I believe CNN and Fox News are limiting it to 10 participants. And I think one of them, perhaps CNN, is going to have a second-tier candidate debate. And those are very important. I'll be watching if I can get to CNN. Definitely be watching. But it is a problem, and yet somehow this court and the United States Supreme Court and the U.S. Senate and the U.S. House of Representatives need to recognize this problem and ensure that they do not just back the temporary advantages of their own major national parties to win the next election, however important they may think that is. They have to preserve democracy. They have to preserve the Constitution and the freedom of expression and freedom of association. Again, I'm Steve Carlson. I approve this. Thank you for watching if you have this far. Most of you might be just the lawyers on the other side. But thank you for watching anyway. And I'll be bringing this message to the American people. I'm running for president of the United States in 2016 as an independent candidate. And this is important work to advance that goal. And I want to see all the independent candidates in the nation out there working for this goal. Thank you.